And as we are in public session, all mobile phones should be switched off as they cause interference, even if on silent mode with the recording equipment in the committee rooms. I have apologies from Deputy Colm Brophy, and Deputy Eamon Scanlon is deputising for Deputy Jim O'Caoláin. This meeting has been convened for consideration of committee stage of the 2018 Coroner's Amendment Bill 2018. I welcome back again the Minister for Justice and Equality, Deputy Charles Flanagan, and his officials. I extend a welcome to all our visitors in the public gallery. Would the Minister like to make some opening remarks on the bill before we go into the amendments? Minister.
Thanks, Caoimhghín. I welcome the fact that we're proceeding on the matter of progress for this important piece of legislation, and I thank deputies, in particular Deputy Daly, for her interest in this issue. If I can briefly say, Caoimhghín, as I already informed the Dáil at an earlier stage, at second stage, subject to the advice of the Attorney-General, I intend to bring forward a number of further amendments to the bill. I am introducing a number of those today, including some new provisions that provide for the first time for an express jurisdiction for a coroner to inquire into a stillbirth where there is cause for concern. Secondly, for a coroner to direct a hospital or health institution where the deceased was treated immediately before their death, or a doctor holding medical records of the deceased to produce the records the coroner considers relevant and necessary for the conduct of an effective post-mortem examination. I wish to further flag to the committee my intention, subject of course to government approval, to introduce at report stage a number of further amendments upon which extensive work is already proceeding. I'll come back to various further amendments during our discussion today as we proceed through the sections. But I do expect them to include, in particular, subject again to the advice of the Attorney-General, a power for a coroner to seek directions from the High Court on a point of law regarding the exercise of the coroner's functions, a case-stated provision, a section setting out governing principles for regulations to be made by me, with the agreement of my colleague, the Minister for Health, on a proper and respectful storage and disposal of human organs or tissue retained for the purposes of an inquest or post-mortem examination, and a number of amendments providing that in the small number of cases where the Garda Síochána Ombudsman Commission is investigating possible Garda involvement in a death under the Garda Síochána Act of 2004, a designated officer of the Garda Síochána Ombudsman Commission may provide assistance to the coroner's inquiry or inquest. Thanks, Caoimhghín.
Tara. So, in that case, we'll proceed. And in relation to Section 1, there are no amendments to Section 1. In that case, I put the proposition to the meeting that Section 1 stand part of the bill. Is that agreed?
Agreed.
Agreed. We go on to Section 2 and the first amendment in the name of Untitled Chapter agus Curtis Greeniness. Minister, would you like to speak to your amendment number 1, please?
Thanks, Caoimhghín. This amendment, in accordance with the advice of the Office of Parliamentary Counsel, makes a grammatical correction in the definition of indirect maternal death to refer not to a, and I quote, previous existing disease, unquote, but more correctly, a, quote, pre-existing disease, unquote. Both terms are used in the WHO definition of indirect maternal death, but the latter appears more grammatically correct, and it also, to my mind, appears clearer. With this amendment, The bill will define an indirect maternal death as, and I quote, the death of a woman resulting from a pre-existing disease or a disease that developed during pregnancy and which was not the result of direct obstetric causes, but which was aggravated by the physiological effects of pregnancy, unquote. Can I say, the definitions of maternal death, direct maternal death, indirect maternal death, set out in the bill are important new definitions which are in line with the internationally recognised World Health Organization, ICD, the International Classification of Diseases definitions. They reflect the initiative on the part of Deputy Daly to ensure the proper investigation of such deaths. World Health Organization definitions are also the ones that are used by Irish doctors.
Okay, Tara, would any deputy wish to take up any point that the Minister has made in relation to this amendment? No. We're okay? We're good to proceed? In that case, Minister, it's my intention to put the proposition in relation to Amendment 1 to the meeting. So, in relation to Amendment 1, in the name of the Minister, that the amendment be made, is that agreed?
Agreed.
Agreed. There are no other amendments in Section 2. So the proposition, therefore, is that Section 2, as amended, stand part of the bill. Is that agreed? Agreed. Yes,
to agreement being reached, Chair, which is my assumption, having regard to the amendment, can I just give notice of my intention for report stage? I may bring forward an amendment on the matter of proposals for the inclusion of further definitions in Section 2, which may be necessary for the better functioning of the bill.
Fine. Minister, your intention is noted.
Object on this, Chair. I think it is a bit unfortunate that the Minister is talking about introducing amendments wholesale at report stage now. There was the possibility of one amendment flagged in discussions yesterday about report stage. We've come from a situation where this committee scheduled a meeting already for committee stage a number of weeks ago to deal with the conclusion of this bill, which was postponed because he said he wanted to bring in a whackload of other amendments. Then we get to today, which we assumed was when that would be dealt with. And now we have references beginning to creep in now to other amendments that we haven't heard of before now. So given that the second stage of the first coroner's bill was moved by me exactly 3 years and 1 day ago, went through second stage. What's going on here? Now, I don't want to unnecessarily, if they're only small things, grand, but what is going on here, seriously?
Well, Minister, could you respond to Deputy Daly
no,
just in relation to
I'm merely,
how substantive are you talking about?
I'm merely acting in accordance with standing orders of the Dáil. It's certainly my intention to limit the number of amendments at report stage. There are a few which I intend flagging, but all of which are in accordance with accepted practice and procedure of the House.
Well, that's very illuminating, no doubt, Deputy Daly.
Well, that's as clear as mud now, because you didn't answer the point that was raised, is that we have been waiting for this legislation for 3 years. We were supposed to have dealt with it about 3 or 4 weeks ago at committee stage. Now you're talking about report stage as if the wheel has been reinvented again when that was flagged nowhere. And that is against the wishes of this committee and indeed all members of the House, including your own party, the length and breadth of the country. But if you're telling me that it's only small things and we have report stage the first week or two back in January, then we can live with that. But what are you talking about, like?
We're unlikely, is my read, to have anything further from the Minister in relation to what he proposes. I'd ask
Chair,
if there were substantive. Please,
can I say that nothing I intend introducing at any stage will run in any way contrary to the accepted standing orders of the House or standing orders of this committee. But can I say, by way of further information, which may help alleviate the anxiety on the part of Deputy Daly, I flagged on the publication of the bill in August that it was my intention to introduce for consideration amendments in order to facilitate further jurisdiction for the coroner to inquire into stillbirths, the power of the coroner to direct hospitals, health institutions to produce medical records of deceased for a post-mortem. I'm tabling these amendments today. I also flagged at the time of publication for report stage on the issue of a case stated, the power of a coroner to seek directions from the High Court on a point of law, provision with governing principles for making regulations on the treatment and disposal of human organs and tissue that may be retained for the inquest, which I referred to in my opening comment. I intend to bring these at report stage, and I also mentioned the issue of a GSOC amendment. So I have already stated that, but
that's okay, Minister. Thank you for that. Deputy Daly, I propose to proceed. I think we're going to just have to bide our time, and report stage will present in due course. So I put the proposition again.
I don't think, Chair, with respect, that this is anything different than any processing of any legislation that appears before this committee.
No, but I think that Deputy Daly's expressed concerns are not unreasonable, Minister. You know, she did bring forward the initial bill more than 3 years ago, and we have been keenly interested in facilitating its progress.
I accepted that in my opening comment.
That's fine.
I specifically mentioned the interest on the part of Deputy Daly.
It's not about that. Like, I mean, look at what it is. We've been people who are the people in the gallery. I didn't invite them here. They came off their own initiative because they're so concerned about the passage of this bill and have a direct involvement in its progress. And we've been at the edge so many times before. All I was trying to do was get clarity from you that is this another delay going on now, or is it just small technical things that will be sorted out? I'm none the wiser on that now. We leave it for now, get this stage on, ultimately it will be a house that will decide.
And the most important thing perhaps in all of this is the Minister being able to indicate the earliest possible address of the bill after committee stage, at report and final stage. I would hope, Minister, that it is your intention.
I would be very keen to facilitate the committee in that regard.
Right. That about sums it up, I hope, at this point. Okay. I'm putting Section 2 again then to the meeting. That Section 2, as amended, stand part of the bill. Is that agreed?
Agreed.
We move on to Section 3. There's one amendment here, Amendment number 2, also in the name of the Minister. This is a new section, Minister, I believe is the reality of your amendment. Would you like to address it, please?
Thanks, Caoimhghín. This is an important amendment which provides for the first time in Ireland an express statutory power for a coroner to inquire into the death of a stillborn child. The bill defines a stillborn child at Section 2 as, and I quote, a child of not less than 24 weeks gestation or of birth weight not less than 500 grams who was delivered without signs of life, unquote. This is the accepted medical definition in Ireland. It's also the definition used in the Civil Registration Act of 2004, whose Section 30 already requires a stillbirth to be reported as soon as practicable to the Register of Deaths. This is a mandatory reporting requirement applied to the doctor, the midwife, the head of the hospital concerned. The Civil Registration Act also provides at Section 28 for the optional reporting of the stillbirth by the family and for the issue of a special stillbirth certificate if they so request. Coroner's Amendment Bill now also provides for mandatory reporting of stillbirths to a coroner. Firstly, point 18 in the new schedule of reportable deaths specifies that any stillbirth must be reported to the coroner. Secondly, Section 6 of the bill inserts a new Section 16b(4) into the Principal Act. It provides for mandatory reporting of a stillbirth by the doctor, nurse or midwife who is responsible for the care of the mother. The Coroner Service website already lists certain stillbirths as reportable to the coroner as a matter of good practice, and stillbirths are regularly reported to coroners by the doctors involved. Coroners indicate that the large majority of stillbirths reported to them are natural and expected spontaneous stillbirths, and are certified as such to the coroner's satisfaction by the mother's doctor. In a very small number of cases, there are circumstances surrounding the stillbirth, concerns about possible medical errors, for example, which do give rise to concern. Coroners are very conscious of the sensitivity of such cases in practice. Further inquiry is rare, is typically where the bereaved parents have requested it. However, the mandatory reporting requirement already introduced by the bill will address the public concerns I've mentioned, will support independent oversight, transparent investigation in the small number of cases where concerns arise. The amendment that I've brought forward today complements the reporting requirements in the bill by providing an express discretionary power for a coroner to inquire into a stillbirth, and if the cause of death remains unclear, to direct a post-mortem examination and, as appropriate, the holding of an inquest. There are two special features. While reporting a stillbirth to the coroner is mandatory, the coroner's inquiry and any post-mortem and inquest into a stillbirth are at the discretion of the coroner, subject to the criteria set out in the new Section 2A, Section 17, 33A and 40 of the Act, providing respectively for mandatory inquest in certain cases, mandatory post-mortem in certain cases, and mandatory juries in certain cases are expressly disapplied to stillbirths. And in exercising his or her discretion, the coroner must consult with a family member of the stillborn child if it is so practical to do so. They must have regard to the views in deciding whether or not to hold an inquest. These provisions recognise the particular sensitivity of these cases and indeed the very diverse circumstances that can arise. The amendment is also a response to the advice from the Office of the Attorney General that a coroner's powers to inquire into a stillbirth should be clarified. This arises because the 1962 Act refers to a coroner inquiring into the death of a person. This phrase is interpreted both in Ireland and in similar coronial legislation in England and Wales as referring to a person who has been born alive, taken independent breath, and has died subsequently, but excluding a stillborn child who has never drawn what can be described as independent breath. In practice, however, media reports indicate a small number of cases in recent years where Irish coroners have held a full inquest into a stillbirth, typically at the request of bereaved persons.
Is that it, Minister?
The parents. The question of extending the coroner's jurisdiction to stillbirths is also being examined across the water in England and Wales, also in Australia, but remains in early stages in both jurisdictions. The proposal was welcomed in the UK by the Royal College of Pathologists and by UK organisations that advocate for patient safety and transparency in the context of stillbirths and neonatal deaths. Conversely, coroners in Northern Ireland can inquire into a stillbirth since a judgment of the Northern Ireland Court of Appeal in 2013 held that the coroners have jurisdiction under a 1959 Northern Ireland statute to hold an inquest into the death in utero of a child who was capable of being born alive. The fact that this is a new question for other common law jurisdictions, in my view, makes it prudent for us to adopt a discretionary approach, at least initially. So proposed subsection 3 sets out circumstances which may be taken into account by the coroner inquiring into a stillbirth where the cause of death remains unknown. Any of these circumstances, if applicable to the death of the mother, would give rise to a mandatory post-mortem and inquest under Section 17 and 33A of the Principal Act inserted by the bill. In conclusion, can I say that as Section 17 and 33A are disapplied to stillbirths, these relevant circumstances are set out in Section 2A(3), simply to clarify that a coroner can still take them into account when exercising his or her discretionary powers.
Okay, Minister Deputy Daly, you're the first to
briefly,
indicate.
thanks, Chair. And this obviously was one which the government did flag to us earlier, and is something that I'm sure we will all welcome, because obviously where there's any question around the reasons of a baby dying either during labour or otherwise, well then those questions need to be answered, not just for the family but also for the health service itself. And while, as the Minister said, what the section isn't providing for mandatory inquests into baby deaths, but it does provide that they will be reportable, and also that other provisions of the Act will apply, like the coroner being empowered to compel the handover of records and so on. And we'd be certainly hoping that, although the power is discretionary, its inclusion here is going to bring us to a safer position in our hospitals, where circumstances like that suffered by the Riley family, for example, whose baby Asha, the investigation into her death took place a full 11 years after she died, thanks to the most appalling actions on behalf of Portiuncula Hospital, and we'd be hoping that these measures will prevent that happening again. I think it's important to put on the record the importance of this legislation, because we constantly hear about the excellent quality of our maternity services, but we have to say that between 2007 and 2017 there were 31 inquests into baby deaths in the Republic of Ireland. In June 2016, the investigation of baby deaths in Portiuncula was only one of many. 7 out of the 19 maternity units at that time were either under an independent investigation or involved in inquests. It's a very big issue, and we need to learn the lessons. And I think we have to say that the added trauma that parents have been put under following the death of a baby, as we saw in hospitals like Portlaoise and Portiuncula, by stonewalling and delaying of hospitals, is absolutely abhorrent. We know from the sample of 30 deaths due to baby deaths due to negligence in Irish hospitals between 2008 and 2016, in every single case where there's a record of an apology or a settlement, it was received 3 to 9 years after the baby had died. And in many instances there was a settlement with no admission of liability and no apology at all. And the parents are on the record of saying what added trauma that caused to them. So look, I'm not going to make those points again, but it is a thread on this legislation that people deserve answers. It improves our health service, and actually, even if you want to be cynical about it, it potentially saves the state tens of millions every year in legal fees. We have to be moving to a situation, give people the information, tell them what they need to know, and improve our services. So I think it's very important, and I obviously welcome it.
Thank you, Deputy Daly. There's no other members showing. I come back to you, Minister. Would you like to
No, I thank
comment
Deputy Daly
further?
I thank Deputy Daly for her comments and her apparent agreement on the matter of the mandatory reporting, and then, as a consequence, the discretionary power on the part of the coroner. What I can say is, having regard to developments both in this jurisdiction and across common law jurisdictions, I repeat that it's prudent for us to adopt the discretionary approach which is contained in the amendment. Thank you.
Thank you, Minister. In the absence of any other contribution, I propose to put the proposition of Amendment 2, which is the insertion of a new section after 2, that the new section be there inserted. Is that agreed? Agreed. Caoimhghín. So there are no other amendments in Section 3, so I put the proposition that Section 3 stand part of the bill. Is that agreed? Agreed. Agreed. Caoimhghín. Section 4, there are no amendments in Section 4, so we proceed to deal with the section. That Section 4 stand part of the bill. Is that agreed? Agreed. Caoimhghín. Section 5, we have an amendment tabled by Deputy O'Caoláin. Unfortunately, it has been deemed out of order, representing a potential charge on the revenue, which I think is always unfortunate, because members have validly considered the merit of the proposition, and having it deemed out of order on that basis is most unfortunate, I do think. In any event, that is the determination. There are no other amendments in Section 5. In that case, I put the proposition that Section 5 stand part of the bill. Is that agreed?
Agreed.
Agreed. Caoimhghín. We're moving on to Section 6, and we have an amendment from the Minister. So in that case, yes, we have a grouping. I see that. In Section 6, we have amendment number 4. 4 to 7 are being grouped. Each of these are in the Minister's name. So we're dealing with 4 to 7 inclusive. They're all related and they will be discussed together. Minister, would you like to address this grouping, please?
Thanks, Caoimhghín. My contention being that these are technical drafting amendments to Section 6, and I would be asked that they would be treated accordingly on the basis of their technical nature. Section 6 provides for a more strengthened regime for reporting of certain debts to the coroner. It inserts a new section 16A and 16B in the Principal Act. 16A sets out an expanded and clarified list of the types of death which must be reported to the coroner, while Section 16B sets out an expanded and clarified list of responsible persons who are required to report such a death to the coroner. So, accordingly, in respect of amendment number 4, in page 11, line 8, to delete prior to and substitute before, amendment 4 is a technical drafting amendment. This was suggested by the Office of the Parliamentary Counsel in order to ensure consistency. So 16B3H is amended, will provide that a person who had care of the deceased person immediately before his or her death is required to report the death to the coroner, if indeed it is a reportable death for the purposes of 16A. In number 5, if I can move, while it may be technical, it's important. The amendment provides for an additional category of persons who are responsible under the new section 16B3 for reporting a death to the coroner. Those who were responsible for a person while he or she was in state custody or detention immediately before his or her death. It would apply, for example, to the governor of a prison. Amendments 6 and 7, again, I would contend that these are purely technical, providing for the re-lettering of the remaining paragraphs in new section 16B3 of the Principal Act as inserted by section 6 of the bill. The re-lettering is needed following the insertion of the new paragraph 16B3(1 as discussed under amendment number 5.
Okay.
No.
That's it, Minister.
Thanks,
You've addressed the 4. So 4 to 7 inclusive. Would anyone wish to? Deputy Wallace, please.
Yeah, just Minister, on the area of Amendment 5, you were clarifying as to what exactly the responsibility, how that's defined. So you're saying that it's actually the governor who would actually be tasked with reporting it, rather than, would say, the individual who might have. If for example, a prison warden was first to find out about it, but the onus falls to the governor, is that right?
Yes. And
in the case of, say, if a guard who puts someone in a cell after arresting him, is it the sergeant in charge, or would it be the superintendent that would actually be tasked with reporting in that situation?
Assumption would be it would be the officer in charge of the Garda station. Yeah.
Not the individual who put him in the cell then.
Where did that may take place? Officer in charge.
Whoever had responsibility for the deceased person.
Right, okay.
Yeah. All right, Deputy Wallace.
Thanks.
Fine. I think these are technical in nature. I don't think there should be any issue with them. So, in the absence of any other comment, I'm going to take them, each of them together. This is Section 6, Amendment number 4. That the amendment be made, is that agreed? Agreed. We move on to amendment number 5, also in the Minister's name and already discussed with 4, that the amendment be made. Is that agreed? Agreed. Caoimhghín. Amendment number 6, also already discussed with 4, that the amendment be made. Is that agreed? Agreed. Agreed. And amendment number 7, again in the Minister's name, already discussed with 4, that the amendment be made. Is that agreed? Agreed. Agreed. That concludes the amendments in section 6. So the proposition, therefore, is that section 6, as amended, stand part of the bill. Is that agreed? Agreed. Agreed. We move on to section 7. And 8 and 9 here are related and will be discussed together. Amendment number 8 are in the names of Deputies Daly and Wallace, and amendment number 9 is in the name of the Minister. We're taking both of them together. So I'll invite Deputy Daly or Wallace, in whichever order, to address their amendment, please.
Okay, and I mean, this is the substantive section really of today's discussion in many parts, and we'll take some time on it because it's the meat and the sandwich really. And I suppose we have to start by saying, like, you know, this is the bit about mandatory inquests, which are for maternal deaths, which is really going to have a triple effect when it's implemented. It's going to give families the fullest picture about the train of events that led to the death of a loved one. It'll give clinicians and the HSE really a crucial insight into where the system is failing women, and it'll give us as policy makers and the ones who are holding the purse strings the information, I suppose, to make our services safer. So it's critically important, and I think we should say the reason why I was a bit stressed in asking about the amendments at report stage is that I'm very conscious that a number of the people who are in the gallery today, midwives, husbands who lost their wives, were here 3 years ago looking for this legislation, and 3 years on, a number of other women have lost their lives in our maternity service as well. So it's beyond urgent, but I would, while saying that and recognising that that's where, if you like, the tetchiness came from, because I don't want to see report stage delayed. But that said, I want to be absolutely clear that we are in a completely different place now than we were 3 years ago. We are on the verge of delivering this legislation, no question or doubt about that. So it's important to say that. But this is the one that we are pushing, and I want to give a reason why, because it gets to the heart of a lot of what we're talking about. Now, the World Health Organization estimates that about 88 to 98% of all maternal deaths are preventable. Shocking. Shouldn't or didn't need to happen. And obviously every single one of those is a tragedy, but we need as much information as possible delivered, we think, through inquests into maternal deaths to make our services safer. If you like, if you take the case of the death of Tanya McCabe in March 2007, the inquest in that found that Tanya and her son Zach had died as a result of septicemia and returned a verdict of medical misadventure. As a result of this, the HSE created guidelines on the management of septicemia, something that should have been implemented in all maternity units. Of course, we found out a number of years later in the inquest into the death of Savita Halappanavar that only 5 of the 19 maternity hospitals or units had implemented those guidelines. So in other words, without the inquest in the original death and the latter one, we wouldn't have had the guidelines or found out about their non-implementation. So it was critically important in developing the services. Now, in terms of our specific amendment to the bill, what we're trying to do here is make it absolutely crystal clear that we, in cases, if you like, that a decision by the coroner to not hold an inquest, because we're talking about mandatory inquests into maternal deaths, but in a case for a coroner not to hold an inquest, will only be taken after a family member asks for it, and if the coroner is satisfied on the basis of the post-mortem and other information available that the death of a woman was a natural one. Now, this arose even 3 years ago in second stage. This was the big issue, if you like, where the Minister at the time, Minister Harris, had said we didn't want the unintended consequence of a bereaved family having to go through an inquest where the causes were obvious and they didn't need an inquest because, say, maybe it might have been a pre-existing cancer or something that there was no dispute about. And nobody wanted to re-traumatise people in cases of a tragic but natural death, as it were, and force them to go through an inquest. So what we've been trying to do then is strike the balance between a family's needs and the wider public interest. And I suppose we have to be absolutely sure that it doesn't happen, that under this section, deaths which are avoidable don't get the inquest that they should. And we think the way the government have framed the legislation at the moment, it gives a little bit too much latitude to the coroners. Little bit too much. It's a bit too broad for us to be entirely comfortable with at this stage. And we'd be happier with a situation where it would be only possible for a coroner to decline to hold an inquest if they'd been specifically asked not to, in writing by a family member, as well as, of course, being satisfied on the basis of the information that they had, including the post-mortem, that the death was natural. So I think it's not strong enough at the moment. Now, I would say the issue for us isn't that we think the coroners are going to be declining inquests left, right and centre. We don't believe that to be the case, and I want to put that on the record. I fully accept that these instances will only happen in very exceptional cases, but it's still important because the concern boils down to the fact of whether a maternal death is a natural one or not is not always obvious. And we need to be clear on that. Maternal health care is getting more complex. Our knowledge of what a maternal death is changing, and what a natural death is changing. There has been a fall in direct maternal deaths, which is to be welcomed, probably as a result of improvements in our health service. But the number of indirect maternal deaths has actually increased due to issues like, for example, obesity and diabetes, which are now a huge problem in Irish society and indeed in many other European countries as well. This, I suppose, means that clinicians and coroners are faced with what one researcher called increasingly intricate associations between underlying medical and pregnancy-related pathology. In other words, it's now more than ever likely that a death that looks natural and looks like it's nothing to do with a pregnancy might actually be a maternal death. And that's the issue that we're trying to get to the heart of here. It's changing and understanding the links between these complex medical factors is important, and it is one which the coroner mightn't actually be up to speed about. So entirely innocently, they might think that the death is a natural one, for example, a heart attack. They say, oh no, look, it's clear the woman died of a heart attack. That's natural, could happen to anybody. But the reality is that an aneurysm that was made more likely by pregnancy, which could have been avoided in the course of the right medical pregnancy treatment, might have altered that situation. So that's the type of thing we're trying to get at. And that we don't think that there's, I suppose the window that of discretion that's currently available to the coroner to not hold an inquest should be closed a little bit further. There should only be the option there if the family specifically requests it. We also, I suppose, we should put on the record, because in some ways this is where it started, but what we want to avoid is a sort of worst-case scenario where it's less a case of intricate associations to even obvious ones. And I'll use the example of the death of Bimbo Onanugwa, who died in March 2010. Now, on the basis of a perfectly written, perfectly correct post-mortem report submitted to the coroner's office, the coroner first ruled that there was no need for any inquest into her death, as he deemed her death was one of natural causes. But subsequent queries by international experts centred on what lay behind the rupturing of her uterus and what was the train of events that led to that moment. And when the coroner was subsequently presented with the queries and granted the inquest, he asked for 19 depositions and witnesses from the hospital concerned, and ultimately there was a verdict of medical misadventure. So the point here is that initially the coroner was satisfied that it was natural on the basis of the post-mortem, but that subsequently turned out to not be the case. So that's what we're trying to do here. I do recognise that once the bill is law, there will be a very strong positive obligation on the coroner to hold an inquest, which wasn't the case previously and will be the case under this law. I realise fully that under this law, for the coroner to take a step to decline an inquest when the bill is law would be much more serious than before, that there isn't a huge amount of wriggle room in that scenario. However, the concern remains if it's the coroner who starts the process of exercising discretion in regard to whether or not to hold an inquest, then the whole point of discretionary element to making things better for bereaved families will be lost, and an inquest which maybe should have taken place wouldn't be. So that's really where this is coming from. We do feel strongly about it. We don't think it's huge. All it does is tie the hands of the coroner a little bit tighter. We know they're tied a bit, but a little bit, so that it's cut and dried, that the families are respected, but the health service gets the information it needs. So.
Thank you, Deputy Daly. Deputy Wallace, did you like to add anything at this point? No, but you can reserve the opportunity to come back. Minister, you're in this grouping, amendments 8 and 9. Would you address them both, please?
Thanks, Caoimhghín. Could I mention in the first instance the point raised by Deputy Daly in terms of the time frame here, and acknowledge on the part of government the urgency here, as well as the importance, and I would be very keen if we complete committee stage of the legislation today, that we could next term be ready for the report stage, and I mean early. And I want to say, not by way of any reason or excuse for any perceived delay, but just to acknowledge that many people who are working on amendments to this legislation and who are engaging with Deputy Daly and others on this committee were very much involved in the current termination of pregnancy legislation. It may well be reasonable to assume that will have been enacted by the end of this year, which I want to assure this committee that there will be no delay in proceeding to the next stage, and certainly the intention would be that by the end of the first month of next year that we would be in a position to seek a date with yourself, and I know the urgency on the part of this committee, and can I say that it's one that's shared by me in the context of issues that have been raised. So just on the matter of this amendment, and it's important, I want to stress that under the current provision, under my provision, there are 3 tests that the coroner needs to engage in. Firstly, consultation with the family member of the deceased woman. Secondly, to have due regard to the matters listed in subsection 4, including, of course, the views of the family member of the deceased woman, which is the point raised by Deputy Daly as to whether the death was a natural one, as well, of course, as the results of any post-mortem examination, and that the coroner needs to be satisfied that the death was a natural one, and that an inquest is therefore in the circumstances not necessary. So if all of these tests are satisfied, the coroner then decides, and the coroner has that decision-making capacity as to whether or not to hold an inquest. But it's after due and careful consideration. I think Deputy Daly really gets to the nub of the argument when she, towards the end of her contribution, mentions tying the hands of the coroner. I think it's important that we recognise the independent and official capacity of the coroner And my concern would be that on Deputy Daly's amendment, that we could well be tying the hands of the coroner, who, irrespective of any considerations, would have to inquest every maternal death or every late maternal death, unless a family member of the deceased requested otherwise in writing. And I see that as being, in many respects, unduly restrictive of the independent role that the coroner has in law. I also am of the view, Chair, that the amendment creates a further issue in that effectively the action, or indeed the inaction, of a single family member in many respects can exercise a greater level of authority than might in the circumstances be necessary, where individual family member may be in a position to unilaterally decide whether an exception which is provided for reasons of public policy will apply to a maternal death. So my view is, I say this with some sympathy to the point raised by Deputy Daly in her amendment, but my view is that the coroner will be inclined to hold an inquest in any event if the death is clearly unnatural, and even if it may be unnatural. And I think we've got to look at the long-standing approaches that have been taken by coroners, and indeed under the existing legislation under Section 17, requiring that it shall be the duty of the coroner to hold an inquest in relation to a death if that coroner is of the opinion that the death may have occurred in an unnatural manner, or indeed in a violent manner, as is in the legislation. So I want to stress the point here that in arriving at a decision, the coroner is required to have regard to all of the evidence, and can I say, with specific reference to the proposed Section 17(3), and that's in relation to the results of the post-mortem, the views of a family member, whether sufficient information has at the time been made available. And I have to say again, in practice, that coroners do attach considerable importance to the views of the family, and rightly so. I note also Deputy Daly's amendment removes the statutory obligation under Section 17(3), which currently, which will require a coroner to engage in active consultation with a family member, and that's important. Important to acknowledge that there may be circumstances where family members might disagree with each other. Oftentimes, an individual family member might take a different view to other members of the families. And in such circumstances, when they arise, I believe it's important that we acknowledge a matter of general public policy, that the coroner acts as an independent public official, never in any capacity as a private individual, or never in circumstances where there might be any connection, perceived or otherwise, to the deceased. And it's the coroner who makes the final decision on whether a death which may appear natural should, in the public interest, be the subject matter of an inquest or not. And I have to say, that I do regard that as a fundamental principle of the system. And I would be concerned if we in any way move towards weakening that, or changing that in a way that might be regarded or perceived as being in some way compromised. And there isn't a precedent for making an exception to this principle. So I acknowledge with certain sympathy the point raised by Deputy Daly, but I want also to stress the independent role and function of the coroner, and indeed long-standing practices on the part of coroners in any event, and the mandatory obligation that there will be in respect of consultation.
Thank you, Minister. Deputy Wallace, then Deputy Daly.
No, just to make the point, we think that we're trying to do the same thing as the government, only probably in a different way, where the government's wording creates at least the possibility that a coroner could actually go against a family's wishes and decide not to hold an inquest. That wouldn't be possible with our wording. Equally, the government wording creates a situation where it's possible for the coroner to be the one who starts the ball rolling in terms of a discussion about maybe not having an inquest. But the goal here, in the government's own words at second stage, is to avoid a situation, and I quote, whereby a bereaved family might find itself having to participate in an inquest which it may not wish for in certain circumstances. The goal is not to give coroners a route out of holding maternal death inquests. Well, I think that's an unintended consequence of how the government have worded the bill. With our wording, it's only the family who can precipitate any conversation about not having an inquest, nobody else. A final consequence of the government's wording is that it leaves too wide a gap through which deaths that look natural but aren't could slip, meaning inquests that need to be held are not held. If the goal here is to protect bereaved families from having to go through a process that on the basis of all the facts of the case is necessary, our wording achieves that. The government's doesn't. I mean, we're trying to put safeguards in place for women, and let's make sure that's exactly what we're doing and leave no space for that to not happen.
Deputy Daly, Deputy Chambers to follow.
Yeah, I think that sums it up very well. I mean, the point about this is, Minister, the whole legislation does tie the hands. We're instructing coroners now to mandatorily have an inquest in case of maternal death. So that's what we're saying. The only exception that ever emerged was in cases where it wouldn't be necessary. It was so obvious that the reason was so clear and that we didn't want to traumatise the family again. That was the only exception that we all wanted to do together. And I think, as Mick said, our amendment allows us to do that. Yours doesn't, because it allows a scenario, albeit it may not happen all that often, but it gives the possibility of the coroner deciding not to hold an inquest in a case where it should be. And we have to remember that, I suppose, maternal deaths are different, because you're talking about otherwise healthy people interfacing with our, medical system or whatever in our maternal care and ending up dead. It's a huge issue. They were otherwise healthy, and the underlying events that led up to that and the examination of that it's hugely important. So it's again to make the point, what might appear natural to a coroner or in the post-mortem, or the report from the hospital, the underlying issues, it may not have been, and we're losing valuable information there if we don't keep our amendment as it is. I take the point about consultation. We're not opposed to tidying that up at report stage, because obviously the family's decision not to have one should be after consultation with the coroner. That's accepted, and we'd be open on that bit, but at the same time it should be the family's decision, not the coroner's, and that's the whole purpose of the bill, and that's what we're trying to achieve. So,
thank you, Deputy Daly. Deputy Jack Chambers, please.
Yeah, no, just to make a comment, I think the present wording where you say, it's quite open-ended in terms of discretion, where you say whenever he or she thinks proper, which I think is too open-ended for what Deputies Wallace and Daly are trying to achieve with their amendment. I also think, Minister, your own amendment around just the second part, where you insert the views, if any, kind of, removes the focus on the engagement with family members, where you're inserting nearly an ability for the coroner perhaps to opt out of that level of consultation that you aspire to in your words. So I'm just wondering why you're inserting, if any, after the views in section 7.4d, and that would it not be better to leave the present wording as exists?
I actually meant to comment on Jack's point, and I totally agree with that. I'd forgotten about that, and I meant to say, obviously if our amendment passes, this amendment will be redundant, but if our amendment doesn't pass, I'm definitely opposing this precisely because of the point that Jack makes. I mean, the whole purpose was, if you like, the whole spirit of this section was supposed to be a coroner exercising discretion to spare the feelings of a bereaved family. This actually stands all that on its head, that the coroner can do it even without the wishes, or even against the wishes of, without the wishes of the family.
Minister, would you like to come back just in relation to this? May I just add a further comment myself, maybe just before you do? I fully appreciate the difference in the two positions. In relation to Deputies Daly and Wallace's amendment, at the request in writing of a family member of the woman concerned, a coroner may decide not to hold an inquest. So there still is a degree of determination on the part of the coroner, i.e., as to whether they do or they do not, may decide not to hold an inquest. They could proceed to hold an inquest. So it's on the, as I would view it, and having followed the whole issue in relation to maternal deaths and the need for mandatory inquests, I think it puts it very positively towards the mandatory position, where the wording as it presents in the bill leaves a degree of flexibility and independent action on the part of the coroner, which won't always, and I agree with Deputy Daly, and I think we'd all be of the view, this, please God, will be very, very rarely employed. It would be preferable that it wouldn't have to be employed at all. But where it does present, I think, and recognising that, having consulted with a family member, when we look at the definitions in relation to, you may not actually have a representative view that's unanimously the view of all concerned. Having consulted with a coroner could speak to, as it states on page 6 of the amending legislation, that includes parent, grandparent, child, brother, sister, nephew, niece, uncle or aunt, and whether of the whole blood, of the half-blood, or by affinity of the person. It's very wide. It's not specific. You could have a consultation with, and in that situation, many others might feel that their views were not properly reflected. In the other situation, at the request in writing of a family member not to hold an inquest, the coroner may decide and could proceed to hold an inquest. I think on the balance of it, my own position would be that I think, given the history of this, given the genesis of the whole thinking behind it, that I think the amendment number 8 is the more appropriate reflection of public thinking on this issue at this time. I just offer that further observation and invite you to respond to our collective views, Minister.
Thanks, Caoimhghín. Without repeating the points raised earlier, I merely want to say that under Section 17(4), there will still be a provision for the coroner to take account of any written views that may be sent in or submitted by the family. It doesn't, in 17(4), provide for an obligation on the part of the coroner to consult with family, but this is in Section 17(3), and that's proposed to be replaced by Deputy Daly. And I think that could be problematic. I would ask maybe Deputy Daly to reflect maybe between now and report stage, as to how best we can meet the concern as adverted by yourself, Chair. I don't think there's much between us in terms of what we wish to see enshrined in our legislation, but I don't want to be accepting amendments that will have unintended consequences. And there are a number of drafting issues to which I made reference earlier. And I want to say that in any event, and there has been reference made by deputies to a number of deaths, indeed some of which have taken place many years ago. And I want to acknowledge the fact that coroners are very well aware of issues and indeed the significance of maternal deaths, and they're well minded to hold inquests in such cases. I want to say that coroners experience regular briefings on the latest research and development. They have a technical understanding of issues to hand that may be developing in accordance with updated research and modern research. And of course, we can expect that that will continue to intensify further as this legislation is passed. So I would ask Deputy Daly not to press the amendment and see how best over the course of the Christmas vacation how we can reflect on reaching a meeting of minds. But I must acknowledge the independent legal role of the coroner in our public service, and somebody who is not directly connected to or with any matters of substance that may appear to be the subject matter of decision.
Okay, Minister. Deputy Eamon Scanlon, please.
Briefly, I can understand the Minister's concerns, but my understanding that this bill was brought here to ensure that where there are maternal deaths, that an inquest is held. That's my understanding of the bill. Now, I'm aware of maternal deaths in my own locality, where the people, the partner of the person, the husband, in those cases, had to fight tooth and nail to have an inquest held. And I'm aware of 2 cases where it took some time and a lot of persuasion to ensure that the inquest is held. And I think Deputy Daly's amendment is reasonable in the sense that people won't have to go through that trauma to make sure that an inquest is held, because as it stands, the coroner has the option, based on the autopsy, whether he will or he won't. I think I agree with the other speakers. I think it's a bit loose. I think it needs to be tightened up. Thank you, Chair.
Whether he or she
He
will
or she.
or they won't. Deputy Daly.
Yeah, no, I mean, Eamon's point is totally right. I mean, the Minister talks about the independent legal role of the coroner, and that is absolutely and totally accepted. But of course, while acknowledging that, we have already got legislation where, despite that independence, there's a mandatory requirement on them to carry out inquests in a number of examples, and we're just adding maternal deaths into that example for all of the reasons that Eamon said. I mean, the only objection put up to this was, well, you don't want to inadvertently damage or harm bereaved families. That's the purpose of why this clause is even been, this opt-out is even there. But as Eamon said, the very reason why this legislation has been tabled, and I'd say the very reason why there's maybe a bit more of an awareness amongst coroners, is because it was precisely the families that led the battle to get this information here. It's going to be incredibly unusual that a family wouldn't want to get the answers, because these are instances whereby maybe the partner was there or the family was there and they have a difference of opinion with the hospital. The hospital is saying, oh, everything is grand here, nothing to see here. And the other person was there maybe with their wife or whatever and saw a sequence of events that they want answers to. So families do want answers. We shouldn't be afraid of that. And I think our amendment does give a better balance. This is about mandatory inquests. So we can look at a tweaking on the consultation bit later on at report stage, but you know, I will be pressing it. I think maybe, you know, if the Minister wants to reflect on it over Christmas, by all means, but I'm happier to go with our wording on it now. And if you want to come back with something different at report stage around the consultation bit, I mean, I'm okay for looking at that, but I think it's critical that we would actually move it now.
Thank you, Deputy Daly. Minister, before responding, there was just one area, related area, that I was anxious about, and that's where an inquest has been denied, and it is very definitely the view of the bereaved that an inquest was important, necessary, that the process for appeal is currently, as I understand it, through the Attorney General. Can you clarify if that is the case? And I just have a sense that that merits a serious reconsideration, because let there be no mistake about it, an Attorney General is a politically vulnerable individual, somebody who sits at the cabinet table, open to the vagaries of the political system. It doesn't strike me as an independent, in every respect, office or office holder. And I wonder, has any consideration been given to that particular matter in the drafting of the bill? And if not, it's something, as you have done yourself, that I reserve the opportunity to bring forward an amendment if having engaged with colleagues, it's appropriate at report stage. I'd appreciate whatever light you can shine on that particular matter, please.
Thanks, Chair. Can I say to Deputy Daly, I'm not sure if the reflection to which Deputy Daly refers will involve her withholding pressing the amendment now in order to see how best we can accommodate the view that she has expressed in the amendment. If not, and if she decides to press the amendment with the support of members, my concern is that Deputy Daly's amendment has one consequence which is serious, whether intended or not, and that is that it would remove the statutory obligation under Section 17(3) for the coroner to consult with a family member of the deceased woman. And I would be concerned if we are now to insert amendments without the type of reflection that I believe is both appropriate and necessary. I mean, under the current provision, there is an obligation, a clear obligation on the coroner to consult and have regard and be satisfied before making a decision. These are thresholds that are inbuilt into the legislation and which can adequately deal with circumstances as outlined. But I am prepared to look further to see can we reach a meeting of minds on it. But I am concerned at a number of weaknesses in the amendment if the committee was minded to accept it this morning in its entirety. And I have to caution against that. Can I say to yourself, Caoimhghín, look, there isn't an appeal, it's an application to the Attorney General to direct that an inquest take place. There is notwithstanding this legislation, something of a major reorganisation of the coroner system. Members will be familiar with the bill of some years ago, and enshrined in that proposed bill was a plan for a chief coroner to look at the matter of appeals. But this is an issue that work continues on. It would involve significant organisational restructure, but it is an issue that is receiving consideration. Of course, Chair, you will be aware that currently there is a provision where a decision of a coroner can be subjected to a judicial review, and that is as well as the application that can be made to the Attorney General.
Yes, well, I thank you for that. It is an appeal. I mean, it's how we lay people would view it in any event, and you did actually use that language in your concluding sentences. To direct, yes, they can direct a coroner or actually override a coroner's previous decision not to proceed. So my question was only because in preparing for today's meeting and informing myself of the methodology of the whole thing, I was a little alarmed to see that this was the recourse that people had. And I don't think anybody who works in this institution will be in any doubt that the Attorney General is hardly an independent arbiter in such a situation. Deputy Daly.
Briefly on the consultation point, because I think the Minister has overly complicated in a manner in which it's not necessary. The bit about consultation that we took out, if you like, which can easily be put back in, referred only to instances where we're removing the bit around consulting with the family before any decision on not going ahead is taken. That's the bit we took out, but it has to be seen in the context of what we're putting in, is that the inquest can only not go ahead if the family initiate that and write to the coroner. So there's no question of the family's wishes being diluted by the proposition that we've put forward in its entirety. We're actually reflecting fully the family's wishes. However, I do accept that prior to the family making that decision, it would be better if they had a chat with the coroner and aired those views in a holistic way. But that's not a big deal, and that can be added in later by you. So it's not that we're taking out a family's consultation or their involvement. The purpose of this in entirety is to put the family's wishes centre stage. And it comes back to the point that we made. This whole legislation, there is a discretion there already for the coroner. We're making it mandatory, and this is one tiny, tiny little exception, which we don't want to be blown apart and put us back to where we were in the beginning. So I think it's just to clarify that point, Chair. Okay. Yeah.
All right. Well,
no, I think it's
the final comment, Minister, please.
Yes, I think it's important to hear like that we don't read the amendment in isolation because of a weakness in inserting it where Deputy Daly has proposed. For example, we acknowledge that the coroner must, under the bill, have regard to all of the facts listed in 17.4, must be satisfied that the death was a natural one, must be satisfied that an inquest is unnecessary. But even if all those tests are satisfied, it appears the coroner cannot decide not to hold an inquest unless a family member asks them in writing. So, for example, if the deceased woman has no identified family members, or indeed if there are no family members who contacted the coroner in writing, it seems in these circumstances that the coroner must hold an inquest, even if there is clear evidence that the death was natural. So I am concerned again that Deputy Daly's amendment and I accept that she may not have intended this, but it does appear to tie the hands of the coroner, who, irrespective of any other considerations, would be obliged to have an inquest, unless a family member requested otherwise, and that request must, under Deputy Daly's amendment, be in writing. And that's my concern, and I would ask that issue be reflected on, and I would offer assistance in reaching a position that could gain favourable consideration across the board here.
Right.
There's no point in us going around in circles, Chair.
Yep.
I do want to put it to a vote. I mean, the whole purpose is mandatory, and if it's that straightforward, the inquest won't be too taxing on them, so I wouldn't worry about it,
In that case, are there any other contributions? No, we're good to go. We're dealing with amendment number 8 in section 7. I believe that it has been properly addressed. Is the amendment being pressed?
Yeah.
Yes. On amendment number 8, the question is that the amendment be made. Éideann Bhóbhar aber Tá. Éideann Gunja aber Níl. I think the question is carried. Vote on. The Minister has indicated that a vote should take place, and as full membership of the committee is not present under standing orders, we are obliged to wait 8 minutes or until full membership is present before proceeding to take the division. Of the 8 entitled to vote, we have currently 6 voting members present. Deputy Scandon substituting for Deputy Ó Caoláin. Caoimhghín. Elapsed, and we are, despite the fact we don't have a full membership present, in a position to proceed. So the question on Amendment 8 is that the amendment be made, and on that question a division has been challenged. Pursuant to standing orders, the division will now be taken by the clerk to the committee. Result of that division, Éideann Bhóbhar Tá a Caoimhghín 5. Éideann Gunja, Níl. Those opposed, 1. The question on amendment number 8 is that the amendment is carried. We now proceed to amendment number 9, also already discussed with 8. Is the Minister pressing the amendment?
I am.
Yes. So the proposition is that the amendment be made. Is that agreed? No. On amendment number 9, the question is that the amendment be made. Éideann Bhóbhar aber Tá.
Tá.
Éideann Gunja aber Níl.
Níl.
I think the question is lost. The question is lost. Amendment number 10 in section 7. In the name of the Minister, I invite the Minister to address his amendment, please.
Thanks, Caoimhghín. Amendment 10 deals with the transitional application of the changes introduced by this bill. Certainly, it's my view that the most straightforward approach legally would be to provide that changes made by the bill apply only to deaths occurring after the commencement of the legislation. However, there is a preference for a broader approach. My amendment limits the application only of the changes made by Section 7 of the Bill to Section 17 of the Principal Act, dealing with mandatory inquests. It allows application even of those provisions to debts occurring before the commencement of the Bill, if on commencement date the coroner has not yet completed their inquiries into the death and hasn't yet decided whether to hold an inquest. Having consulted with the Office of the Attorney-General, having consulted with coroners, it appears that legal complications and legal uncertainty would be likely to arise if the bill were applied to pre-commencement debts, in respect of which the coroners had completed their inquiries and perhaps even held an inquest. Having regard to the large numbers of natural deaths occurring in different types of state custody and detention, for example, it appears from consultation with coroners that requests to reopen such cases with a mandatory inquest now could give rise to a very significant consequence on the coroner system. So I move my amendment.
Deputy Daly, you indicated.
Yeah, just very briefly. I mean, I know what the Minister is trying to do, and the amendment providing that the duty to hold an inquest into maternal death and a death in state custody doesn't have retrospective effect, and I get it in terms of, say, the state having to investigate all people who died in prison of old age and all this sort of stuff. But in terms of maternal deaths, I'd like to hear more, and I think it is worth having a conversation about whether the provision could only be in tandem with some other route for people who've been denied an inquest now, say, prior to the enactment of this legislation. Particularly people were aware of a case, say, recently of a death that occurred a number of years ago, but the husband had never been granted or sought an inquest prior to now, but that process is underway at the moment. Is there some route for people? I suppose what we're looking at is maybe not some formal appeals process or something else that families who are out there now, at this point in time, prior to this, who are unhappy about a decision of a coroner to not hold an inquest, that there would be a route for them under this bill to have their case looked at again without the Minister's problem of retrospective application for all. If we could build something in at report stage, that might be worth looking at. I mean, not opposing the amendment or anything, but if we could look at it.
I would be happy to do that, having regard to the fact that maternal deaths in institutions or indeed in places of custodial detention are very, very rare. We're talking here about young women. But I would be very keen to pursue the point raised by Deputy Daly with a view, and I'll get some actual figures, but I would ask people to acknowledge the fact that we're dealing with circumstances of very, very rare occurrence.
Okay, Minister, there's no other indicator. In that case, we'll proceed, and Minister, you're pressing the amendment?
Yes.
Yes. So the proposition is in relation to amendment number 10 in section 7 that the amendment be made. Is that agreed?
Agreed.
Agreed.
Agreed, having regard to the valid point raised by Deputy Daly.
Very much, yeah. we understand that. So that concludes the amendments in section 7. So in that case, the proposition is that section 7 as amended stand part of the bill. Is that agreed?
Agreed.
Agreed. There are no amendments in section 8, so I'll proceed to the section itself. That section 8 stand part of the bill. Is that agreed?
Agreed.
We have a number of these, so be patient with me. Section 9, no amendments. That section 9 stand part of the bill. Is that agreed?
Agreed.
Section 10, no amendments. That section 10 stand part of the bill. Is that agreed?
Agreed.
Section 10, yes, and very briefly here, I merely wish to mention that I intend bringing forward an amendment of section 20 of the Principal Act at report stage, intending to provide for permitting a designated officer of the Garda station of GSOC acting in circumstances where where the Gardaí cannot to assist a coroner, and amending the current provision for an inspector of the Garda Síochána to request a coroner from an adjoining district to hold an inquest by providing instead that it would be for the Minister to direct a coroner or deputy coroner. Again, I'll have those amendments as soon as possible.
Very good. So we've already agreed section 10. I'm moving on to section 11. There are no amendments. That section 11 stand similar?
Similarly, I intend to bring forward an amendment on the matter of the adjournment of an inquest where criminal proceedings are either being considered or have been already instituted. Right.
So I proceed with the proposition that section 11 stand part of the bill. Is that agreed? Section 12, there are no amendments. I was waiting, Minister.
Yeah. Again, let me flag amendments at report stage, proposals in respect of authorising designated officer of GSOC to provide support to the coroner in procedures for identification of the body of the deceased.
Fine. So the proposition therefore is that section 12 stand part of the bill. Is that agreed?
Agreed.
Yeah. Agreed. Caoimhghín. Section 13, amendment number 11, in the name of Deputy Donnacha O'Leary. Deputy O'Leary is not here. Not moved, but I just would reflect that Deputy O'Leary is entitled to resubmit for report stage if he so decides. Isn't that in order? Thank you. So, not moved, that means there are no amendments to, no amendments, to section 13. So the proposition is that section 13 stand part of the bill. Is that agreed?
Agreed.
Agreed, Caoimhghín. Section 14, there are no amendments. So I proceed to put the proposition that section 14 stand part of the bill. Is that agreed? Caoimhghín. Section 15, there are no amendments. That section 15 stand part of the bill. Is that agreed?
Agreed.
Agreed. Caoimhghín. Section 16, amendment number 12. We're on the penultimate, the second last amendment as put before us. It's in the name of the Minister. Minister, would you like to address amendment 12, please?
I would, Caoimhghín. Thanks. This amendment deals with the production of appropriate medical records of a deceased person for the purposes of a post-mortem examination. The new provisions provide that where a coroner has directed a post-mortem examination into a death, he or she may also direct the head of the hospital where the deceased person was treated immediately before the death, or a doctor who has medical records of the deceased, to provide the pathologist conducting the post-mortem examination with such records as the coroner considers necessary to enable a proper examination to be made. The amendment is considered necessary to enable the coroner to carry out his or her statutory functions effectively and to ensure the fullest possible transparency in relation to the investigation of unnatural deaths or where a cause of death may be unclear. It's expected that such records would be provided on a voluntary basis on request by hospitals or other health institutions. However, difficulties have arisen in the past in certain cases where the coroner had considerable difficulties in obtaining appropriate records over a sustained period of time. It's particularly critical that relevant medical records of the deceased be provided in a prompt and timely manner. The window for conducting the most effective post-mortem examination is short, optimally, often within 24 hours of the death. This provision is intended to make it clear that the coroner has the power to compel the production in case of difficulty. Some of the finer points of this amendment are still being teased out with Parliamentary Council. I intend to propose further amendments of this provision at report stage, particularly regarding appropriate enforcement provisions. We are considering in this regard what enforcement provisions would be the most effective having regard to the fact that we're dealing here with an urgency that can and will apply in these circumstances. So I propose the amendment, but I would do so with a commitment to consider adequate provisions in respect of enforcement. Indeed, possibilities might include, in addition to an offence, a power for the coroner to apply ex parte to the High Court should records not be forthcoming in a prompt and timely manner. Again, I would be happy to hear the views of members of the committee, but I do accept the fact that while the amendment is important, that we do need to look at the matter of enforcement.
Thank you, Minister. Deputy Daly, your
just very briefly, Chair, and in fairness, this was flagged to us as something that the Government would be bringing forward at committee stage, unlike some of the other issues which I'll deal with in a second. But this one most definitely was, and we fully support the Minister in his efforts on this, and in fact would echo the points that he made, that our support on it is, I suppose, dependent on some sanctions being included at report stage, because there's no sanctions at all on medical institutions or hospitals that refuse to hand over records now. So on the understanding that these sanctions will be put in, we're very happy to accept it. But rather than, I suppose, just to make the point, this one was flagged. A number of the issues that the Minister raised and the other flags weren't flagged at all in the conversations that we had in preparation for this bill, or I'm pretty sure some of them not even at second stage. Some of them were flagged at second stage, dropped in the pre-discussions about committee stage, and are now being re-entered. But that's something maybe the committee can deal with after today's session. I just wanted to put that on the record. But this one was flagged and we fully support it.
Yes, I'd just like to record fully supporting as well, Minister. Can I just clarify the reference to registered medical practitioner? The pathologist most certainly would be, and I presume that the pathologist's request this would also, I mean, that's understood. Absolutely. Yeah, because there hasn't been heretofore any mandatory release of records or full hospital records to pathologists, and it has been a significant weakness, and there is ample evidence of where this has not been done. So
thanks, Chair. We intend addressing that.
Okay. Are we good to proceed with this? Deputy Daly, you had nothing further to add? No. Right. In that case, Minister, we're going to proceed. Amendment number 12. I will put it to the meeting that the amendment be made. Is that agreed?
Agreed.
Agreed. Caoimhghín. And that's the last amendment in Section 16. That Section 16 as amended stand part of the bill. Is that agreed?
Agreed.
Agreed.
I might mention, Chair, in that regard, intention to bring forward an amendment at report stage to ensure the best and most effective approach to post-mortem examinations. Enhanced provisions, for example, on the conduct of post-mortem examinations by registered medical practitioners, the powers to remove, to retain human tissue and other material during a post-mortem examination. The provision may include a power for the Minister, in conjunction with the Minister for Health, to set out by regulation code of practice for post-mortem examinations. We don't have such a statutory code at present. I'm also looking at provision for a new power allowing the coroner to request the Minister to order the exhumation of a body in the very rare circumstances where the body has already been buried, but the coroner may well be satisfied that further post-mortem examination is required and that such an exhumation is in the circumstances justified, and provision for a defence post-mortem. Again, these are very rare, but may well arise where a person is accused or is likely to be charged of a criminal involvement in the death of another person very soon after the death. In such a situation, the High Court has confirmed that the accused is entitled to request an independent post-mortem examination of the body of the deceased, in addition to the examination already carried out by the Office of the State Pathologist. This independent defence post-mortem differs necessarily in some important respects from a coroner's post-mortem. For example, It's facilitated but not directed by the coroner. I believe it's important that a statutory provision for the defence post-mortem would provide more clarity for everybody concerned, acknowledging that it's a complex area, but it would enable, for example, provision for the appropriate balancing of the rights of the accused person and the family. Indeed, defence post-mortems can be distressing for the family of the deceased. In this regard, any delay should, of course, be kept to an absolute minimum. Thanks.
Thank you, Minister. We're dealing now with Section 17. We've already, or did I put the proposition? That Section 16 as amended stand part of the bill. I think that, yes, we've acceded to that. Section 17. There are no amendments in Section 17. That Section 17 stand part of the bill. Is that agreed? Agreed.
Very briefly, in respect of Section 17, while Section 17 of the bill amends Section 37 of the Principal Act, I intend bringing forward at a report stage amendment which refers back to Section 17 on the matter of Section 36 and the service of summons on the Principal Act. Again, it's merely an enabling provision to facilitate the service of a summons on behalf of the coroner, requiring the attendance of a person at an inquest as a juror or witness in a death that is under investigation by GSOC, for example.
Okay, Minister, thank you for that. Section 18, there are no amendments. That Section 18 stand part of the bill. Is that agreed?
Agreed.
Agreed. Section 19, there are no amendments. That Section 19 stand part of the bill. Is that agreed?
Agreed.
Section 20, there are no amendments. That Section 20 stand part of the bill. Is that agreed?
Agreed.
Agreed.
On 20, Caoimhghín, can I again just indicate for the benefit of committee members that I intend to bring forward an amendment to Section 40, subsection 3 of the Principal Act, which suspends any obligation to have a jury in place if the inquest has been adjourned at the request of An Garda Síochána. What I intend doing is to reflect the intended amendments already described to Section 25, with particular reference to requests for adjournment of the coroner's inquest made by various statutory bodies other than An Garda Síochána, which might be charged with the investigation of deaths, including GSOC.
Noted.
Similarly, under 20, an amendment to provide that a designated officer within the meaning of Part 4 of the Garda Síochána Act of 2005, a designated officer of GSOC may assist the coroner in summoning a jury at inquest where the particular circumstances of the case require such assistance.
Very good. Now, sections 21 to 30, that's 10 sections in total. And to avoid my having to repeat myself, there are no amendments in any of the next 10 sections. So I'm just going to merely cite the proposition. I'll start with 21. That Section 21 stand part of the bill. Is that agreed?
Agreed.
Again, Chair, without wishing to be seen as intervening unnecessarily, but just to say that I intend to bring forward at a report an amendment to Section 47 of the Principal Act, extending the power to request the exhumation of a body in some circumstances. Currently, only the Garda Síochána have the right to so request at present.
Moving on to Section 22, that Section 22 stand part of the bill. Is that agreed?
Agreed.
Again, in Section 22, an amendment which will permit the involvement of a designated officer of GSOC in assisting the coroner's exercise of power under the section in cases which fall under a GSOC investigation, with particular reference to Section 22, which provides for a new power for the coroner to enter premises by consent or indeed under a warrant of the District Court to take possession of any any documents or article or substance or item that might be relevant to the coroner's functions regarding a death. Warrant may be issued by district court if the judge is satisfied on the sworn information of a coroner that there are reasonable grounds to suspect that the premises contain such documents or things that may be required by the coroner for the purposes of the inquiry. And again, that will involve the attendance of an appropriate officer from GSOC, should the circumstances warrant.
Moving on to section 23, that section 23 stand part of the bill. Is that agreed?
Agreed.
Section 24, that section 24 stand part of the bill. Is that agreed?
Agreed.
Section 25, that section 25 stand part of the bill. Is that agreed?
Agreed.
Section 26, that section 26 stand part of the bill. Is that agreed?
Agreed.
Section 27, that section 27 stand part of the bill. Is that agreed?
On that section, very briefly, Chair, again to formally indicate a proposed amendment providing for a new section to be inserted after section 61 of the Principal Act in relation to cases stated and the procedure for coroners in a case stated circumstance. The intention would be, subject to the advice of the Attorney-General, to provide for a consultative case-stated type process, would allow for a coroner to apply to the High Court for directions on a point of law relating to the performance of his or her functions. Under the Act, it is proposed that the High Court would determine such an application by giving directions, making such orders as it may consider appropriate. But I want to reflect the fact that in common with other quasi-judicial bodies, coroners are being called upon to conduct inquests in a more adversarial and perhaps challenging environment than was heretofore the case. While coroners are not deciding the issue of adversarial litigation, they nevertheless, as we know, are required to conduct an inquest in accordance with administrative law. And they need to apply principles of procedural fairness. They need to comply with requirements of the European Convention on Human Rights Act. And they are increasingly dealing with complex and sometimes challenging points of procedural law, which are raised by the parties to the inquest from time to time. I merely cite an example of applications for discovery of documents to be provided to the coroner. These are issues that all of which, again, I would say, are very positive for ensuring the system is adequately robust. And I intend bringing forward a small number of amendments to this section.
Moving on to section 28, that section 28 stand part of the bill. Is that agreed? Agreed. Caoimhghín. Section 29, that section 29 stand part of the bill. Is that agreed?
Agreed.
Agreed. Caoimhghín. Section 30, that section 30 stand part of the bill. Is that agreed?
Agreed.
Caoimhghín. We're on to the schedule and the final amendment, amendment number 13, in the Minister's name. I'll invite the Minister to address his amendment, please.
Thanks, Gerda. Can I say this is amendment on the advice of Parliamentary Council. I propose to amend this particular reference to avoid possible confusion and even non-reporting of deaths. In Schedule 2, as inserted by Section 28 of the Bill on page 25, line 35, to delete the following words, I quote, a hospital or other institution, unquote, and to substitute words, an institution. My concern is that referring to a hospital or other institution in point 23A of the Schedule of Reportable Deaths, that there could be an issue regarding interpretation. It might be interpreted as suggesting that other references to an institution in the bill excluded a hospital unless that specific mention was made. So this schedule which Section 28 of the Bill inserts as a second schedule to the Principal Act, contains a list of specific examples of the type of deaths which must be reported to a coroner under new Sections 16A and 16B of the Principal Act. I seek support of the committee in that regard.
Okay, is there anyone wishing to comment on that? I take it, Minister, that an institution for the care and treatment of persons with a physical or mental disability includes care homes managed by the HSE and by other entities, including across the Section 39 cohort. All of that would be the case. So this is a catch-all for all situations, as it must. And again, it's for reporting to the coroner. That's it. Right, in that case, there's no other indication, and I record supporting what the Minister seeks. So in that case, we'll put the amendment number 13 in the Minister's name to the meeting, that the amendment be made. Is that agreed?
Agreed.
Agreed. Caoimhghín. So, schedule, that the schedule as amended be a schedule to the bill. Is that agreed?
Agreed.
Caoimhghín. Now the title, I have to say that this be the title to the bill, an act to amend the Coroners Act 1962 and to provide for related matters. Is that agreed?
Agreed.
Agreed. Caoimhghín. As consideration of the bill has been completed, in accordance with Standing Order 90, the following message will be sent to the Clerk of the Dáil. The Select Committee on Justice and Equality has completed its consideration of the Coroner's Amendment Bill 2018 and has made amendments thereto. I again thank the Minister and his officials for attending here this morning. I thank the members of the committee for their work, not only in the engagement this morning, but very especially to Deputy Daly, who has put a considerable effort in over a long and protracted period of time, helping to bring this bill to this particular point. I'd like to thank our visitors who have joined us here this morning. History is a much used word, but hopefully this was an historic little moment that we've all been witness to. So, with nothing further to say, the Select Committee is adjourned sine die. Caoimhghín.